Please rise. Court is now in session.
When a hospital investigates a serious medical mistake, the patient, and often their lawyer, never gets to see the results. In this short episode of I Strenuously Object, partner Bill Rogel takes a closer look at something called peer review privilege. That's the legal protection that allows hospitals to keep many internal investigations confidential. He explains why those protections exist, but also asks an important question. If the goal is better patient safety, is the system actually working? If you or someone you love suspects that they may have been the victim of medical malpractice, this short episode will give you a better understanding of an issue that most patients never even know exists.
Call the first witness.
What I want to talk about a little bit today is peer review in a hospital setting and peer review privilege protection. So look, first of all, I get it. It's good for patient safety to have doctors and hospitals and hospital administrators and 7 layers of administrative staff and people whose entire job is sitting on these committees, all getting together to do assessments of what has gone wrong, why a particular adverse medical outcome, and particularly why a place where there was malpractice or a place where the system broke down, they can investigate that, look into that, determine the cause, and figure out what they can do about it to make it better. In theory, in the abstract, yeah, that's a good thing. We want them to be having these meetings. We want them to be talking to each other. We don't want everyone immediately kind of retreating into a CYA mentality, where the people who made the mistakes and the people who know there are mistakes feel like there's only harm and nothing to be gained by discussing those mistakes openly and learning from them. Okay, so I understand that that's the environment onto which peer review protection is grafted and why there's privilege that attaches to it, so that you can be open and honest and candid and not be worried about the confidential proceedings getting out. But 2 things. First of all, boy, does that specifically vindicate the feeling that we plaintiffs' lawyers get about the way that doctors and medical providers think about lawyers and the law, right? Which is, we can't be open and candid and honest unless we're sure the lawyers are never going to hear it. That's not the thought process you want your doctors and your medical providers to have as a default way of dealing with the world, right? We live in a society which has decided the way that we compensate patients who are harmed by the negligence of medical providers is through the civil justice system. There are other options, I suppose, out there. You don't have to rely on civil courts to do that. You could just have some government administration set up, but that's not what we do here. We in the United States and have decided that the civil court process is the correct mechanism to compensate these plaintiffs. And nevertheless, the adversarial relationship to that justice system is so baked in that we've decided and encoded into our statutory law that the only way our doctors can honestly talk to one another about their mistakes and make plans to be better in the future is if they know the lawyers are never going to hear about it. But it's not just the lawyers not hearing about it. The patient never hears about it, right? It seems kind of like a crazy place to land that you're going to have 30-person committees sit around and review the medicine to decide what happened, what went wrong, why did we kill Jane Doe? But we're not going to talk to Jane Doe or her family about the contents of this. We'll send them a general letter that kind of might flag to them that something happened that may not have been what was expected or proper, and give them the name and number of a patient safety representative to call that they can choose to speak to. But not inviting the patient, not disclosing the results to the patient. Again, there are some theoretical public goods that are advanced by letting this conversation happen in a maximally honest place. But we should at least stop and pause and take stock of the fact that it seems weird that the patient doesn't get a say in any of this, doesn't have a voice in any of this, doesn't have an ear in any of this. And all of the focus on what happened to this patient is taken away from and out of that patient's hands. And the results of that investigation are never disclosed to the patient, never brought forward to the patient to say, hey, here's what happened. Here's what we did wrong, right? Because God forbid we do that. Some court somewhere might make us compensate you for the injury we caused you. And this is really the last place I want to talk on peer review here is I have not seen any particular statistical evidence that this peer review process internally that these hospitals are doing is working. We've all seen the studies that medical malpractice is the third leading cause of death in this country. We've seen how bad the numbers are. I have seen scarce little evidence that all of the talking that's being done in committees, all of this risk management and policy and procedure drafting that these hospitals are doing as part of this peer review process is actually doing anything to keep our patients safer. And that's the goal here. I get why, in theory, this whole process makes a lot of sense as at least a way to try to make patients safer. But I don't think it's working. And I do think that it's a problem in basically any other profession. If I get together with my boss, my supervisor, my coworkers, and we all talk about, hey, what went wrong yesterday that caused Jack over there to get hurt? That conversation becomes subject to discovery later. If I do an internal investigation, my internal investigation is subject to discovery, review. I have to turn it over. I don't get to try to gain all the knowledge myself and not share it with the people I injure or the people who represent the people I injure. We treat doctors differently, and especially in hospitals differently, and especially in this regard. And I'm not sure that the theoretical justification is being borne out in practice, that it's actually working, that it's actually saving lives.
Are you suggesting a change of some kind?
It's a little premature. Look, different states can do different things, right? The rules aren't exactly the same in every place. I think New Jersey doesn't have a statute governing this at all. In theory, what I'm suggesting is at least exploring the option of, hey, look, if this peer review stuff, if the layers and layers of administrative expense that are going into investigating these things after the fact aren't materializing into real actual patient safety, then either get rid of it altogether or just change and strike and reduce the privilege. Let that investigation be discoverable. Turn it over to the patients, the people you injured by the malpractice that you're all sitting in a committee discussing. You're all sitting around over weeks and sometimes months, 10 people, 15 people, 20 people, 30 people, doctors and administrators and patient safety specialists all sitting around talking about what happened. At the end of the day, you're going to do a root cause analysis. You're going to figure out what happened, what went wrong, and you're going to make suggestions about how to make things better. And then you never share that with the person that you found in your investigation was injured by malpractice by your hospital, facility, doctor, whatever, right? The person who was injured is the last person to know, the only person who can't know, because they might file a lawsuit. They might be a plaintiff in a malpractice action seeking compensation. We wouldn't accept that from a driver of a vehicle, right? Where you hit someone else at a red light and you get to go home and talk to, you're in a company car and you go home and you talk to your boss and you tell him what happened and you try to justify why you didn't do anything wrong. And he does his own investigation and he looks at the car's black box and he, talks to his, own specialists in this regard, and they convey a big old meeting. And you later on, you who was injured in the accident never get to hear about it. It's specifically legally protected. And there are other places where, as a matter of public policy, we create evidentiary privilege, protection against things being used against you because the value of the candor in the relationship is important enough to protect. But here, the thing that it's supposed to be doing is letting the hospitals really address the underlying causes of malpractice and make the places safer. And I just don't see any evidence that it's actually working. Not when the malpractice rates are happening more and more, and it's the third leading cause of death in the country. Where is the evidence that the whole reason we're letting this happen and letting it be abnormally legally protected from discovery by plaintiffs who were injured by medical malpractice? The only possible justification for not letting a patient who was injured know the results of the hospital's investigation into how they were injured is if in the long run it's making other patients down the road safer, significantly safer, demonstrably safer. And I haven't seen that.
What do you think it would take to change, to open up this process? Because I could see doctors being very protective of this confidentiality and fighting back hard.
Well, they are, and to some extent, there should be considered a distinction here between, and there is sometimes and there isn't sometimes, between the doctors and the insurance industry in this regard, right? There was a lot of political wrangling and lobbying from important constituencies and influence groups on all sides, right? Like, there are attorneys who are involved in lobbying groups, and it's not just the insurance industry that's doing it, but the insurance industry and the doctors are definitely the ones who have kind of, in a standard push all over the country, helped be involved in the crafting of these laws, ostensibly under the guise of patient safety, but as part of that, including this privilege that bakes in the idea that being honest with the patient, or being honest with the patient's lawyer and telling them what you actually know about what went wrong, is bad. And that we have to hide that, or else or else everyone's just going to circle the wagons, CYA, clam up, and nothing will get better. Why are those the only two options? Why can't we mandate that the hospital have actual investigations after something unexpected happens, and mandate that the results of that investigation be shared with the patient? Locally, our hospitals are nonprofits. If what happens is money moves from the hospital to the patients who were injured by medical malpractice, that's a good thing. That's what you're supposed to want. The money that's going to build new hospital facilities because they don't have shareholders to distribute their funds to is instead being diverted to compensate patients who are injured by medical malpractice. Why is that bad? Why is that a problem? Why do we give so much deference to the hospital's economic interest in not paying patients that it injures, that it knows it injures, that it has a big investigative meeting to determine how it injured and why?
Thanks for listening to this quick take from I Strenuously Object. As Bill explained, peer review privilege exists to encourage hospitals to openly examine medical mistakes and improve patient safety. But it also means that patients and their lawyers may never see the results of those investigations. Whether you agree with Bill's conclusions or not, understanding how this process works is an important first step if you believe you or a loved one may have been harmed by medical malpractice. If you found this episode helpful, please subscribe, leave a review, and share it with someone who might benefit from it. You can find more episodes of I Strenuously Object wherever you get your podcasts, and learn more about Flaherty, Fardo, Rogel, and Amick at pghfirm.com. Thanks for listening, and we'll see you next time.